a real pleasure to welcome such distinguished scholars, practitioners, members of the bench to the Market for Corporate Control of the Zone of Insolvency program symposium. Last night with the Resi Roundtable, we had a robust discussion of the issues about the overlap between M&A and insolvency, M&A and bankruptcy. And so today the hope is to follow up those conversations and get into greater depth. We have a long history of sending our graduates across the river to be leaders in both areas of practice. Today, among other things, not other areas, you're going to hear from Dennis Block, our great friend. Dennis Block is a triple threat super lawyer, member of the class of 1967, and a member of our board of trustees. And we're wearing him out. He's also an adjunct professor here and has an extremely important class. I see him, we used to overlap every Monday night, but I've been out most Monday nights trying to shake the trees for money, and so I haven't been seeing him in class as much, but we're very grateful to have Dennis here. He's extremely knowledgeable in the field. We also take great pride in being a center of excellence in business law. And what does that mean? By the way, that prompts a thought. Some of you heard me say this last night. I heard somebody yesterday make a comment in order to make a point. Somebody who I respect and love very much, but he was trying to make a point, and he said that we are not an elite law school. And to borrow the words of the Florida students, I call out BS, okay? And certainly, if you just focus in this field, as I pointed out at greater length last night, in the field of bankruptcy law, I believe that we are second to none. And I think that's demonstrable if you just look at the people in this room, if you consider the quality of the exceptional faculty that we have, the full-time faculty, tenured faculty, Professor Janger, Professor Fanto, who works in the related in the field, Michael Gerber, the adjunct resources we have, including a great example I mentioned, Dennis Block. All of our graduates, there were 20 people present last night who graduated from the school and clerked in bankruptcy courts, and then all our relationship with the bankruptcy judges and so on. I really believe that it would be hard not to make the case that in that aspect of corporate law, as well as others and in other fields, we are indeed among the elite. But when you're talking about a center of excellence business law, what do you really mean? Are you talking about securities regulation? Are you talking about commercial transactions? Are you talking about antitrust? Are you talking about tax? Are you talking about bankruptcy? And in the academy, these issues tend to fall into silos. But in practice, in contrast, because the real world doesn't have those kind of lines, the question is blurred, and in reality, when you're acquiring a company, whether the firm is solvent or insolvent, whether it's in bankruptcy or out of bankruptcy, may have an impact on your answer to the question in terms of what is the relevant law. The regulators may change, but the transaction doesn't change. The regulatory hoops may be slightly different, depending on whether the company is insolvency or not. They're just sort of hoops that they have to leap through that are different. Does it really matter? Would it be better if we kind of converge the questions or the areas of law? Maybe that's not right, maybe that's wrong. These are some of the questions that you're going to get into today. And it'll be challenging, as I understand it, some assumptions such as, are the markets for solvent firms different from markets for insolvent firms? Are there particular dangers associated with M&A in bankruptcy that need to be guarded against? Are there shortages of information, say compared with solvent firms? Are there shortages of information or opportunities for obstruction when acquiring a bankrupt firm that don't exist or are more easier to remedy than when the firm is solvent? And is there even a greater or just a different role for law and therefore judges and practitioners in those transactions involving insolvent entities? So I look forward to reading the answers in the symposium volume that will be published in the Brooklyn Journal of Corporate Financial commercial law. I'm looking around the room, seeing many of the people that are going to have a hand, I think, and others in the future in helping to turn that into a very important document and reference material. The students are here today, and they have just been putting the finishing touches on a very important volume discussing public bankruptcies in cases like Detroit. So a real cutting-edge issue. Next year's editors will turn today's discussion into a polished scholarly volume. So the student who's completing his note that's soon to be published with me in the elevator, you'll be off the hook because you're graduating this year, but the people who follow you will be working on that project. The tremendous impact and influence of our journal is in no small measure due to the quality of the symposia like this, but it's due to the vision of one of today's participants. I don't see her.
Yeah, actually, that was why I was running up to you. Roberta's got a cold, so she's
Okay.
not going to be here.
All right. So Roberta is not here, but we know we're all talking about the one and only Roberta Carmel, who, among many other things, including her long service on our faculty, was the first woman commissioner of the Securities and Exchange Commission. And I understand, among many, many other things, you know, when she had a sabbatical, people have a notion of sabbatical as a vacation. She tossed off these 2 volumes, you know, sort of My Life at the Center of Law, or so whatever that title is, 2 huge volumes. And one of the things that's really remarkable was that she, I think this is correct, that she wrote the first dissent. There was actually no mechanism for a dissent in terms of SEC decision or commissioner deliberations. So, yeah, right. And a very remarkable woman. So 14 years ago, students in the Securities Law Association approached Professor Carmel with a request, and we want there to be a law journal. And in the words of Star Trek's Captain Jean-Luc Picard, Roberta made it so. So she garnered support from the faculty. She created a first planning board, organized the first 2 symposia, and got the journal off and running. Today's program would not have been possible without her. And thanks to the Brooklyn Law Center for the Study of Business Law and Regulation and its co-directors, Professor Janger and Professor Fanto, we thank them for making the symposium possible today. They also have brought us recently other important events, and I know that Ted is trying to get me tripped up here because he wrote in sci-fi right after Picard in Star Trek, but I'm told it's SIFI, right? SIFI.
Just ask Don.
Right. So we had an important program on SIFI, and also the Young Bankruptcy Scholars Workshop earlier in the year, and that was organized with the assistance of our friend from the University of Texas Law School, Jay Westbrook. And Jay, it's great to see you here again. I mentioned to the folks from Texas every chance I get what a wonderful experience my son Tyler had there and how much he enjoyed and got out of his experience at Texas Law School. I'm very personally grateful for that. Well, that's probably quite enough for me. I'm going to turn this over to Ted, and I wish you all the very best. My office is right downstairs on the 9th floor. If anybody needs anything at all, I also think I have a couple extra boxes of Girl Scout cookies that I bought from one of our professor's daughters. So if during the day you need anything or help with travel at the last minute, just let me know. Thank you all very much. Have a wonderful symposium.
Thank you, Nick.
So, need the mic. So, welcome, everyone. Some of you who were here last night have already sort of had an amuse-bouche on the topic for the evening. For the rest of you, you'll catch up quickly, or are already, or your thoughts are unpolluted by what we did last night. I wanted to sort of take 2 seconds to say welcome, but also to talk about the ground rules and for the day, partially because I just have a way I like to do these things, partially because I forgot to tell everybody before they got here. So it's been a busy week. The first thing is the important difference between this and a CLE, right? This is not a CLE in the sense that we are talking to a bunch of lawyers to instruct them about the state of the current law. This is a symposium where we're aiming towards an academic volume where we already have a number of papers in early draft, and then we've got a bunch of people who are writing, or in my case, haven't written yet, their draft. But the hope here is that we, in fact, are engaged in a cooperative effort to advance our thoughts and improve the papers that are already in process. So it's not just that the people in the front of the room are talking to the people out in the broader circle. We want to hear from, one, I've set it up so that there's going to be interaction throughout the day, and two, those of you who are not in the squared circle should feel free at the appropriate moments to weigh in. And the way the day is basically going to be structured is that we're going to keep moving people around. The panels will be up front, and then people will circulate around. The speakers will be given a maximum of 15 minutes. They don't have to use it all. The panels, the idea though is to, we always, as academics, and watch me do this, right? Say, we're going to be brief, and then we go on at great length. So 50 minutes maximum, no obligation to use all of it. I will be keeping time. That will be a hard stop unless you don't make eye contact with me. And then we will open it up, first to the people around the table, but then to the general room to have a broader conversation. A couple of weird bits of logistics. David Skeel, who was on this morning's panel, is for the good of the country, but not for the good of this morning, on the Puerto Rico Oversight Board. You may have noticed that I made this panel 15 minutes shorter because I was always worried that David was a little bit probabilistic. What I didn't anticipate was that the governor of Puerto Rico would be in New York today. Now, that works in two different ways. One, notwithstanding the weather, he is in New York. Notwithstanding, but because of the governor, he's not here just now. He has said he's going to try to sneak out and come down for as much of today as he can, and we are going to we'll squeeze him in wherever we can fit him. So there's only 3 of us sitting up at front right now. Okay, that's it for that's it for the ground rules. Now I'm going to take a few minutes. Oh, the other thing is that Adam Levitin is going to be mercilessly teased by me for the rest of his life for being a weather wimp. He is stranded in D.C. The good news is that his paper is a joint effort between me and him, so we're going to Skype him in and I will present it, which means unfortunately you'll see a little bit too much of me. All right, so just laying the ground rules. What I want to talk about is sort of setting actually, I'm supposed to be keeping time.
I should have excused myself for my own.
There we go. Okay. So what I want to talk about sort of to get the day going is to sort of lay out what I think are sort of the broad strands of tension as a company goes from being a solvent firm to being an insolvent firm to being in play as an insolvent firm to being in bankruptcy to being in play in bankruptcy. And what, as Nick pointed out a few minutes ago, we all tend to be a little bit siloed. Whenever I tell Roberta I'm going to do a program about bankruptcy and corporate law, she said, I don't know anything about bankruptcy. Roberta knows a lot about bankruptcy, right? But we tend to sort of live on one side of the line or the other. I don't know enough about corporate governance law as a bankruptcy guy, but I know a lot about governance in bankruptcy. So part of the idea of this symposium is to sort of get people who know a lot about both to talk to each other and sort of compare and contrast the regulation of corporate controlled transactions outside of bankruptcy to the way we do it inside of bankruptcy, and to pose the fundamental question, are they the same? Are they different? What are the differences that matter? And a third one, which is the difference insolvency or is the difference being in bankruptcy? Right? In other words, is this an economic situation or is this a law situation? And that's sort of the overarching puzzle that I have, which is there an event horizon and how do things change? The thing that I'm going to talk about particularly is once you're in bankruptcy, what I'll call the interest alignment and process solution that bankruptcy tries to impose on the problem. And talk about something that I've been thinking about a lot for the last few years, which is when is bankruptcy legal process a good thing that helps, and when is it something that gets in the way? So when does bankruptcy process or when does judicial process help to control abuse, and when does it become an opportunity for parties to use leverage or to obstruct or engage in abuse? Now, some of you who know me well know that I've got sort of a couple. I realized actually as I was thinking about this program that I've sort of proposed solutions on both sides of the equation, one in dealing with quick sales, which is a paper that I did with Melissa Jacoby called Ice Cube Bonds, and the other is a paper that I've been working on with Adam, which I'll talk about in the afternoon, which is dealing with obstruction in the plan process, which we call mark-to-market governance. So I want to sort of show that, see if I can tie all of that together in 8 more minutes. Okay, so let's start with what corporate control transactions look like outside of bankruptcy. What are the bits of governing law? Important to recognize that outside of bankruptcy, there's no court until things go to hell afterwards, right? So you start with the officers and directors and their fiduciary duties and their disclosure duties. We then move on to the investors, to the extent that you've got creditors and suppliers who are dealing with the company. They are governed by contract law and tort law, and to the extent that you've got shareholders who are changing the ownership structure of the company, they are governed by the securities regulation, fraud regulation, and disclosure regulations. Okay, so that's sort of the basic broad architecture outside of bankruptcy. In bankruptcy, the funny thing is it looks entirely, it doesn't look entirely different. All the words change, right? Instead of talking about the debtor, we talk about the debtor in possession. Sometimes we call that the trustee, but we really mean the debtor in possession. And we have to ask different questions. To what extent are the fiduciary duties the same or different in bankruptcy? We then add on a set of representative bodies to deal with other creditor constituencies that out here would have just been people the company was doing business with, now are claimants to who have an interest in the outcome. We don't know who has a duty to them, but creditors who have governance rights now in bankruptcy, and to what extent do they have fiduciary duties? To what extent are they subject to insider trading and restrictions? And then, to the extent that we've got people who are again, in the individual investors, there's a limited disclosure obligation under Rule 2019. And we've got sort of broad prohibitions on inequitable behavior, but they don't come into play that often. So that's sort of the quick and dirty inside versus outside regulatory scheme. Once you get into bankruptcy, you have a fundamental question if you're going to do a corporate control transaction, which is, do you do this thing under a plan of reorganization? It can be done, in other words, you can sell the company in a plan, you can restructure the company in a plan, or do you sell the company early in the case or outside the context of a plan? And what's striking, and this is where the process interest alignment distinction begins to look graphically problematic. If you're going to do it under a plan, the bankruptcy code has a significant architecture for making sure that information flows, that various interests have, that discrete interests have an opportunity to negotiate over their distribution and actually have veto rights in the form of voting rights and class acceptance provisions, right? So there's a fairly robust process for figuring out how to allocate the value to decide whether to go through with the transaction and to allocate its value. On the sale side, really there's less there than even I have on the chart. There's 363B that says the court can approve a sale outside the ordinary course of business, and then everything else is somewhat up for grabs. And we've cobbled together a series of objections, the idea that somehow this shouldn't be an end run around a plan, and somehow there ought to be respect of the entitlements that would exist if you were doing a plan. But that's all being dealt with, one, on the fly, and two, with no explicit link up between what's going on over here and what you have to do over here. And that's just been something that, that practice, well, it won't be a surprise to anybody in the room that there's been a hydraulic pressure to do it this way, right? To do it as a sale. Okay, and so that then leaves us with a spectrum. It's a spectrum that I've laid out in bullet points, right? Which is, on the one hand, you have the sale side, which by virtue of its stripped down nature does something that could be very helpful. It empowers the plan proponent to run through things that might be obstructions. Now, this is a feature on some level. If you think about the insolvency situation outside of bankruptcy, and you think about state law debt collection and the rush to dismember a debtor, one of the problems outside of bankruptcy is that too many people have vetoes on keeping the company going. And so bankruptcy limits that a little bit through the plan process. But to the extent that we've now moved to sales, it limits it a lot, right? It basically allows, you get the automatic stay, everything stops, and then we basically give a hammer to the plan proponent, who then walks into court, and I'll say this again, and says, this is the only deal we've got, we have to do it now, and by the way, this is how the money's going to be distributed, and take it or leave it. And the bankruptcy judges in the room all know that's not such a fun place to be as a bankruptcy judge. Are you the one who's going to say stop? And it's not such a good place to be if you're someone an investor who just found out about this thing 2 days ago, and you haven't figured out what you think, and you're going to stand up in front of a judge and say, I object, and they're going to say, why? And you're going to say, I don't know yet, right? So you have problems that come up early in the case on information, one, about whether it's a good deal, and two, about whether this thing is being used to force a bad deal or to force a particular allocation of value that may distort the bankruptcy priority scheme, and you just don't know. Flip side, on the plan side, when you have to go through all of the hoops and jumps, there may be too many opportunities to empower a holdout. If you think about a proxy fight or a fight outside of bankruptcy over a corporate control transaction, you basically got the shareholders, you've got one big class of shareholders who are fighting over whether this is consistent with fiduciary duty. In bankruptcy, all of a sudden, you've got multiple classifications of creditors, all of whom have the right to accept or reject the plan. And on the one hand, you do have the power to bind class holdouts. But heck, I can buy up 30% of a class at 10 cents on the dollar and throw a wrench. And so suddenly, on the plan side, the plan process can actually lead holdouts with significantly more power in bankruptcy than they would have outside of bankruptcy. And so what do you do about that? And this is sort of where I'll wrap it up and then turn it over to the, I'm going to, how am I on time? Yeah, not that good. So, skip a whole. So let me just do this quickly, right? Don't worry about the slide, just listen to me. So on the sales side, the argument is always there is a blanket lien creditor who owns everything and therefore it should all go to me because I'm not getting paid in full. An important thing that ought to be possible in bankruptcy is a more careful examination of whether this blanket lien creditor really owns everything. And towards that end, I've proposed, and other people have come up with other ideas. I've suggested that at least in sale cases, you probably can do the sale if it's a good deal, but you need to possibly hold back some money to sort of preserve the discussion about allocation until later. Now, Jay's going to talk about why that can be alternatively a nightmare scenario, but we'll save that. I'll leave that for him. On the plan side, and we'll talk about this again more this afternoon, one of the things that I think would be worth thinking about is whether there are ways of ensuring, and Henry's going to talk about this a little bit. Actually, it's not what you're going to talk about, but we'll talk about it later. It's not what you're talking about today. Henry's written a lot about this, is whether there are ways to ensure that the people who are exercising their governance rights in bankruptcy are acting in a way that's aligned with the estate. And Adam and I have a suggestion for how to work, how you might do it. The comment that we've gotten on it is, surely you're right, but that will never happen. So with that sort of laying of the table, I will turn the mic over to Henry. You can see. Do you want to come up? Either way. Yeah. I'll just go back to.
Well, I'd like to thank Ted for inviting me to this very interesting symposium. There were 3 econometricians who were off on a hunting trip in Wales, Canada. And it was getting near lunchtime, and they were getting hungry. Luckily, they see a deer off in the distance. First econometrician picks up his rifle, shoots, but misses a meter to the left. Second econometrician picks up his rifle and misses a meter to the right. Third econometrician doesn't pick up his rifle at all, but shouts in triumph, "We got it, we got it." Now, it's really hard to come up with a good model, much less one that actually puts food on the table. And for securities lawyers and academics, the one solution for everything is disclosure. And today, I want to suggest that disclosure does not work very well in terms of distressed companies that haven't yet filed for bankruptcy. Okay? And that, in fact, that this undermines the market for corporate control. That's kind of a theme of this conference. And I want to offer some tentative thoughts on 2 questions. One, does this disclosure, the basic disclosure model, work for these troubled corporations? And second, if it doesn't, what do we do? In terms of the first question, when you talk about the normal, healthy corporation, managements have lots of incentive to do out for their personal reputations and from the point of view of the reputations of their companies, to maintain long-term access to capital markets, to provide lots of disclosure, warts and all, to help their corporations maintain access to capital, to help their personal reputations as in terms of people of integrity and so forth. But with a troubled corporation, there's a high probability the management's losing their jobs and losing their firm-specific human capital. And from the point of view of the corporation, there may be no long-term. And it's important to kind of emphasize, like, you know, kind of the end days problem, right? That, in a sense, things are unleashed. Base instincts are unleashed, so that, for instance, on the last day in office, right, the Friday a few weeks ago, Janet Yellen got rid of 4 directors at Wells Fargo. Or Bill Clinton, on his last day, pardoned a fugitive financier, Mark Rich. So in these extreme circumstances, managers may behave very differently in terms of disclosure relative to the normal, healthy company. I was going to say something about the current president suddenly imposing 25% tariffs on steel, but I won't say that. Okay. Securities law. In terms of securities law, it kind of exacerbates some of these problems in terms of disclosure, in terms of troubled companies. That is that the chances of liability are probably less in terms of fraud. So for instance, in terms of the classic pathway to a securities fraud action, it basically depends on the fraud in the market theory adopted by the Supreme Court in Basic v. Levinson. But you don't apply the presumption of this fraud on the market theory if the defendants can show that the particular securities involved do not trade in an efficient market. So routinely, if you are defending against a securities class fraud action and your client is a small company, you try to avoid class certification by basically saying, hey, so few analysts follow our company, or there's such low institutional ownership of our shares that we're not traded in an efficient market. Sometimes they win. Well, with a financially troubled company, the market cap may have really dropped, may have dropped very low, that there may be fewer securities analysts or very few securities analysts following it and the like. And the value of the common stock may be especially low. Now, bondholders, of course, may have more of a stake. But as we all know, corporate bonds tend to be much less liquid, especially junk bonds, and that you could make a strong argument that, hey, these corporate bonds are may not be trading in an efficient market, so you may not be able to bring a private class action because of this basic Levinson issue. Secondly, in terms of the management's discussion and analysis, SK 303, right? That's the central narrative discussion in terms of 10K disclosures, right? That you're supposed to provide through the eyes of management, not just in a sense perspective on the past, but importantly, perspective on the future in terms of everything from capital to liquidity, results of operations. And that you're supposed to provide lots of information with respect to the financial condition, results of operations, with particular emphasis on the prospects for the future. And so you're supposed to discuss things like liquidity problems and the ability to continue meeting debt covenants and what you might have to do in order to do the steps you have to take to continue to try to meet those covenants. So for a troubled company, especially, boy, this MD&A is supposed to be a treasure trove of information. But interestingly, in fact, there's a split in the circuits right now, basically between the Second Circuit and the Third and Ninth Circuits, as to whether a private plaintiff can, in fact, bring a cause of action against an omission in the MD&A item, right? And the Supreme Court, noting this split in the circuits, was going to deal with this matter in the case of Leidos, but unfortunately, Leidos settled, and so the case is no longer in front of the Supreme Court. And so there's a real issue right now, depending on what circuit you might get sued in terms of whether there is private enforcement. And given how stretched the SEC budget is, right, especially, one wonders whether, in a sense, just relying on public enforcement is really sufficient. That you take away the kind of you reduce the chances of serious private enforcement. Third, there's gaps in information under the existing law relating to the corporate control issue. Like with a normal healthy company, when you're talking about things like major events like change in control, you do have 13D and so forth. Various ways of subverting 13D. But 13D is still out there. Well, when you think about it, in the case of a financially troubled corporation, there have been instances of what I've called empty creditors with negative economic exposure. So that is that you would have these creditors, people who hold loans or bonds, and they may have very large holdings of credit default swaps at the same time, that they would have the incentive, these creditors would have the incentive to in fact push the company into bankruptcy, to use the control rights given to them in the bond indentures or in the loan agreements in terms of, for instance, consenting or not to some third party coming in, injecting capital, that these people will have very little incentive to agree to steps that would save the company. And yet, how does this relate to disclosure? Well, there's a general issue that sometimes, very often, these companies are not even aware who these empty creditors with negative economic exposure are. So it's a real problem there. So another kind of major gap that's different is when you're talking about a company that is financially troubled, it's not entirely clear what the corporate objective is. What are the managers trying to do? That is, thank goodness the Supreme Court at least cut back credit liene to insolvency, right? So that we don't have the ambiguity about zone of insolvency, whatever that meant. But still, even in Delaware, it's not entirely clear when you're in insolvency exactly how to apply these very ambiguous notions that Delaware Supreme Court has proffered in the North American Catholic case. But there are also states where, in fact, there is no case like credit liene or North American Catholic. And like I think the last time I checked a couple of years ago in Texas, there was no controlling precedent in terms of what the corporate objective was when you're talking about a financially troubled company. So if you don't really even know what the managements are supposed to be doing, right, it's really hard to interpret lots of decisions that may be occurring. Okay, so what to do? In terms of what to do, well, one possibility, of course, is the Supreme Court basically do some enforcement activity in this area to send message cases. Indeed, a number of years ago, Kmart's MD&A disclosure was felt to be lacking. This was when they were having problems back as Kmart rather than right now as part of Sears. And so the SEC brought an action. Well, if the SEC were to bring more cases, show they're on the watch for MD&A problems, that may be helpful. Of course, and pending the Supreme Court, in a sense, actually taking another Leidos-like cases, I think that one of the things that the SEC could do is, for instance, shift some of the MD&A obligations over to the Form 8K side, where unquestionably, in terms of 8K, if there's an omission, there is a private right of action, okay? So you get rid of the kind of statutory or legal ambiguity associated with the MD&A that currently exists. So you shift over some of the MD&A requirements over to the 8K side. You could also, in terms of the 8K, add more triggers relating to certain events that may be relevant, that may be important in the financially troubled corporation context that don't apply in the healthy corporation context. For instance, perhaps if the board has authorized discussions with the creditors to effect some kind of consensual restructuring, maybe that should be a trigger. In terms of the corporate objective, of course, Jay and I have argued in the Columbia article that we wrote where there really should be a clean break between the fiduciary duty of a company that's has not legally filed for bankruptcy versus those that are in bankruptcy, and that we ought to, that there are many arguments for that approach, but one of them is, in fact, to avoid this kind of legal uncertainty in the troubled corporations setting where absent bankruptcy. There are a number of positive steps that have been taken in terms of increasing information in terms of troubled corporations, so that, for instance, because of a new FASB rule that became effective in 2016, company managements themselves, not just their outside auditors, must offer a going concern statement, so that the company's managers must gauge whether there are conditions or events that raise substantial doubt about the company's ability to continue as a going concern for a year. The company actually has to make this evaluation and report if it has this substantial or serious doubt on a quarterly basis. Now, auditors have had to do this kind of going concern thing on an annual basis. In terms of this kind of additional kind of requirement on the part of managers, it does seem to have an impact. So for instance, it's interesting, in terms of the 10K the most recent 10K of Sears, the one that was filed in March 21 of last year, management said, our historical operating results indicate substantial doubt exists relating to the company's ability to continue as a going concern. This apparently conveyed real information to the market. The share price dropped 12% that day. Interestingly, Deloitte, the independent auditor, made no mention of going concern issue in the Sears 10K audit opinion. Okay, so there was a difference in terms of view between the management and the outside auditors, although I'm exaggerating slightly because the time period they're required to look at is different and so forth. But anyway, a difference between the two. In conclusion, in terms of the troubled corporation, it's a topsy-turvy world that perhaps some of the usual incentives and usual kind of notions in terms of securities law really don't work very well. That you actually, and in fact, it's a weird kind of situation, like in terms of Sears. Sears management probably wishes they're wrong and that the auditors are right. Contrast to the usual kind of situation. Now, to hammer everything that sticks up as a nail, and certainly securities law lawyers and academics and the SEC suffer from this cognitive bias of looking at everything from the point of view of disclosure. Nevertheless, I do believe that better disclosure is a necessary but not sufficient condition for a better market for corporate control for troubled corporations. Thanks.
Thank you. Don? They didn't even have to wave a flag. It was just perfect.
Oh, I'm ready.
Yeah.
Henry, I actually think that your points are an excellent segue to the comments I'm going to make, because what I'm going to try, is this working, by the way?
Can you guys hear it on?
I'm going to try to link the type of disclosure that you're talking about, which really relates to what's going on mostly before the bankruptcy, and then what happens in the bankruptcy and some of the dilemmas that actually were faced by the American Bankruptcy Institute Commission as it tried to grapple with some of the problems of lack of transparency and the fact that you move from a system where governance relates to state law rights of shareholders, and you're moving into a world where governance very much depends on the relative contract rights of parties who are not shareholders, and how that affects the whole situation. So a couple of starting points. Starting point number one is that every bankruptcy transaction for a large corporation is a change of control transaction, bar none. A reorganization, a sale, it doesn't matter. It's a change of control transaction because there will be new equity holders of an insolvent firm emerging from the transaction. It will not be the old equity holders by and large, unless you have a unique situation like Dow Corning where the debtor turns out to be solvent, but that's very rare. So that's principle number one. Principle number two is the old aphorisms that we hear about the lemons problem. And that is that a company that goes into bankruptcy and has various creditor constituencies who know what's under the hood there is a subset of many people actually who actually have a very good sense of what the company is about and what the problems are and maybe what some of the solutions are. And then there's the rest of the world who really does not get a chance to look under the hood. And even the best due diligence doesn't give the outsider the perspective that the creditors committee or the senior lenders or the ad hoc bondholders committee gets from living with the company for an extended period of time in Chapter 11 and effectively sitting side by side with management and finding out everything about the company, and also knowing about their own strategies in terms of how they maximize value, which is very relevant to whatever outcome you have. So that's principle number two, is there are a lot of people who, when they drive the car out of the showroom, they know what the car is worth, and the buyer isn't so sure that they aren't keeping something from them that may be a problem. So it may be a lemon. So there's this inherent information problem about private information. Principle number three is that contract rights and liens are very powerful things. I'm going to leave for later Ted's problem about the scope of the lien and just assume for this purpose that there is a blanket lien over the entire enterprise value. That you can discuss it later. And this is what created the dilemma for the Bankruptcy Commission because, as we know, at the commencement of a Chapter 11 case with the capital structures we have today, the value of the liens very often exceeds the value of the firm. And Judge Glenn has written eloquently about this in ResCap and dealt with the issue that Ted has raised in one context about the scope of the liens. But the truth is, if you really believe there's a blanket lien, very often the value doesn't exceed the value of the lien. And what that means is that there's a very powerful, perhaps constitutional concept in the bankruptcy code that secured creditors are entitled to adequate protection. And if you don't have the ability to provide protection for the lien, and in fact the value of the lien is deteriorating during the bankruptcy case, it puts the creditors in a very powerful position because they can say, you cannot use cash collateral or you cannot get another financing without our consent. So the senior creditors have a very powerful position. Often the senior creditors may view the company to have diminishing value and they want the company sold immediately because they get all the proceeds and everyone else gets wiped out, but if they let the proceedings continue, there's a risk that their value will erode. Or at least that is what they often come into the court saying. And that means that since they have consent rights over the use of cash collateral, and they potentially have consent rights over a new financing, it becomes very hard for the company to survive in Chapter 11 without acceding to the need to put the company on the block and get it sold very quickly to meet the senior creditor's needs. Now, if the senior creditor had not had access to bankruptcy and had to foreclose on assets, let's say it's a large corporation in many states, they might have realized a lot less than they would realize in a bankruptcy sale. We talked last night about all the good things that you can do in a Section 363 sale, like sell assets free of liens, eliminate causes of action, give releases, and many other things. And so the ability to have a sale process in bankruptcy generates a lot of value. You're also able potentially to leave disadvantageous contracts behind. You can really clean up the business for a buyer. And so the question then becomes, is that something that that senior creditor can get in the bankruptcy case that he wouldn't have been able to get outside of bankruptcy, something that the senior creditor deserves? And this was a dilemma that was faced by the commission. And the way the commission dealt with that at the beginning of the case is it said your rights to adequate protection should be based on your foreclosure value rather than your going concern value. In other words, if you had been able to foreclose outside of bankruptcy, what would you have received? And if the going concern value is higher than that, then you're adequately protected and maybe you can't force a sale. They're very controversial because most of the case law today in a blanket lien context talks about the secured creditor being entitled to the going concern value of their collateral. So that's at the beginning of the case. However, the commissioners were concerned that there is a lot of risk associated with that. And they also recognize that in some contexts it might be more applicable than others. If you think about a company that owns one factory and the factory is subject to the lien, it's different from a multi-state enterprise where you'd be foreclosing in multiple states, and it may be easier to say that the blanket lien creditor really does have all the value of the company in that context. So recognizing that, the commission also said, look, there may be contexts where a quick sale is important, but we want a well-vetted sale. We want actually a decent market test. So we're going to limit the ability to have sales right after the bankruptcy case commences, and we're going to at least allow some period of time for the company to be fairly marketed. And what they suggested is, except in absolute emergency contexts, that 60 days at a minimum be allowed for the company to be put on the block and sold, even in situations where a sale is appropriate. So that was item number 2. Now, item number 3, let's say there is no sale. The problem of valuation variance is a big problem. The most extreme example I can think of that, it was Delphi Automotive, where a private equity firm at the depth of the financial crisis, when General Motors was teetering on filing in bankruptcy and the other automakers were teetering on filing in bankruptcy, the private equity firm offered $815 million for the entire of Delphi. Instead, and that would have paid about 25% of the DIP loan, which was $3.5 billion. And instead of doing that, the DIP lenders decided to credit bid for the company. So they bid their DIP loan in competition, and they actually bought the company in connection with the sale process. And it turned out that after the bankruptcy case was over, the European operations of that entity happened to be extraordinarily valuable, and they recovered multiples of the value of the DIP loan, multiples of the $3.5 billion, instead of taking the $815 million offer. But this is just illustrative of the fact that the valuation variance can be huge, especially in times of financial distress. And we know that a court has to, at the end of the case, if you can't get agreement among the parties, the court is going to do a judicial valuation of the company. And as the great and late Peter Coogan, a professor at Harvard, once said, a bankruptcy valuation is an estimate compounded by a guess. It's an estimate of the future cash flows compounded by a guess as to the discount rate. So valuations at the end of the case, which allocate with finality who gets what in the bankruptcy case, are very, very difficult. And in fact, one of the innovations of the bankruptcy code was to try to minimize the amount of valuations you do by allowing for consensual plans of reorganization rather than having the old rule of Chapter 10 where the absolute priority rule had to be applied in every single case and a valuation was required. Some of those valuations took decades, I mean, literally. So were confronted with this problem. So what did the commission say at the end of the case? There's a very great tendency for the senior creditors at the beginning of the case to want a quick sale, and for the junior creditors at the end of the case to want to hold up the valuation and hold the senior creditors hostage. So what the commission decided was, even though we're going to go with a liquidation value standard at the beginning of the case, we're going to go with a going concern value standard for the secured debt at the end of the case. And that was the compromise they reached. But it's a very uneasy compromise, because the valuation at the end of the case may still be wrong, and you may be wiping out people who actually, if the company, now that it's being reorganized and we're not really liquidating it, is it right to cut people off simply based on a judicial valuation at the end of the case? So the commission, recognizing that, said there's a third compromise. And I'll step back from the third compromise and give you an illustration, and then we'll come to what the compromise was. So in the Conseco bankruptcy, which occurred maybe 15 years ago, the holding company filed for bankruptcy, and largely the assets were a group of insurance companies, and they were able to get the local insurance commissioners to forbear from taking over the insurance companies, because the insurance companies were quite solvent. The company's problem related to believe it or not, a mobile home lending business, and the mobile home lending business rendered the holding company insolvent. And so at that point, you had $2 billion of senior secured debt, you had about $3 billion of bonds, and then you had a bunch of junior bonds as well. So there was a big dispute, because at the beginning of the case, most analysts and the senior creditors thought the company was worth no more than $2 billion. The senior bondholders were absolutely certain it was worth at least $4 billion, and of course the trust preferred, which are the junior class, were convinced it was worth $6 billion. The senior bondholders and the senior secured creditors decided that they were going to reach a compromise, and that no one really, between those two classes, really gave much credit to the trust preferred holders' valuation of the company. And so in advance of bankruptcy, going into the case, they fashioned the following solution. We are going to assume, they said, the $2 billion valuation as a baseline. We're going to issue $1.2 billion of debt to the senior secured creditors. We're going to give them 100% of the equity. We're going to give them a convertible preferred stock for the balance of their claim, the other $800 million. And then the equity, in the first instance, will go to the senior bondholders, the unsecured bondholders. So you had basically a division of the world where the common stock went to the senior bondholders. But the way the structure worked was that if the preferred stock was not redeemed within 28 months, that preferred stock would convert into 98% of the equity, and the bondholders would actually be wiped out. So what they were going to do was allow some time for the market to value the company, and the management and the equity were going to be given a chance to redeem out the junior bonds if their valuation of $4 billion proved out to be true. There was a litigation with the trust preferred holders over whether that plan would be confirmed, and ultimately a settlement in which some warrants were given to the trust preferred holders, and the company emerged from bankruptcy within about 6 months. And about 18 months after all of that occurred, it turned out that the market value of the company on an enterprise value basis was in fact around $4 billion, and they took out the preferred stock that had been given to the senior creditors, and the bondholders ended up with 100% of the company. Now, what that effectively did, that preferred stock created option value for the stockholders. And using that example and other examples, there were just numerous ones in the way these things get settled, the commission said, well, why don't we impose that result? Why don't we say that an option should be issued to the classes that we think are out of the money, and they have a limited period of time, in effect, to buy out the senior classes. And so there is something in the commission report called option value, and they have a hypothetical option with a strike price equal to the value of the senior creditor's claims in effect, where the equity can in effect buy into the company at that strike price. So I'm going to stop there, but this illustrates a fundamental problem that we have in bankruptcy about having a multilateral zero-sum game. We have information gaps. We have pressures from contract rights to reach an early resolution or to wipe out people on a date certain. And the question is there any other way to do it? And if so, how? So I'll leave it there.
Wow, and thank you. I'm going to resist the temptation to engage directly right this second and say, does anyone want to jump in from the... John?
Yeah.
And then I'll keep a queue as people want to, if people want to speak.
Don, I'm thinking about the valuation issues that you describe, and I'm just wondering to myself, do we add in there the fact that there's a lot of noise around bankruptcy? Like when you see the true value shakes out sometime later, because I could see two stories about bankruptcy. I could say, look, bankruptcy is a moment of clarity because everyone starts looking under the hood, and you get the war rooms and you get the committees constituted. So that's like the best and most focused time to assess value is with all these flashlights shining on the debtor, and so we should feel very confident about the scrutiny of the value. Or the opposite story is bankruptcy is freaking chaos and no one knows what's going on, and so you should be loath to ascribe values in that time period, and you should wait to see how things shake out. Do you have any practice, intuition? Is it each case is different, or what do you think?
Look, I think there's always a lot of confusion, and valuation variance may depend very little on the bankruptcy case. It may depend on what's going on in the rest of the world, right? And there's also a high value for certainty, so resolving things and letting the company emerge with a capital structure that's not totally confused with lots of overhang from warrants and other things is important as well. I think this is a very intractable problem. I mean, you could think of a different concept, which is totally different from what we do in our bankruptcy cases, of saying, look, let's let the company emerge from bankruptcy and have an entirely new capital structure based on new financing. And then whatever the securities, whatever equity is issued by that company could be put in trust, and then people can fight over the valuation. And the market will tell you what it's worth. I mean, in Drexel Burnham Lambert, the junk bond portfolio was put in a trust. Nobody knew what it was worth. The securities traded based on what the market decided it was worth ultimately, and they liquidated the junk bond portfolio over time. This is not dissimilar from what happened in the railroad cases where Judge Fulham was doing a valuation of what Conrail took. It was a takings case. Nobody knew where he was going to come out. There was a range, from very low to very high, but they issued to the bondholders certificates that traded in the market, and the market was pricing the value of that litigation. Maybe in a way we should get these companies out of bankruptcy, set them up, and then people's rights to whatever the value that comes out of that can trade.
It seems to me, sorry, I was
Okay,
going to
no, go. Go ahead, and then Marty.
I think the point you're making about there being extraneous circumstances and point in time are really, really critical. Sure. I was going to say, I think the points Don was making about valuation being difficult, but because it is at a point in time and the effect of extraneous circumstances is really key. Take oil and gas. Oil and gas firms, when oil is at $35 a barrel, are worth a heck of a lot less than when they're at $120 a barrel. Most oil and gas bankruptcies that I've seen and been involved in, it's not mismanagement by the company. It's not a problem with the capital structure in the abstract. The basic problem is where oil is trading. And the problem when you're representing, as I've done on occasion, unsecured bondholders in a case where on current valuation the secureds are, we're out of the money, is my guys will say, but 6 months from now, or a year from now, or 2 years from now, oil is going to be back at 120, or it'll be at 80, or it'll be at 90, or it'll be somewhere. And it does strike me that one solution to that problem is giving options or warrants to basically say, okay, we're not going to do a valuation as of this depressed instant in time, permanently eliminating the rights of junior note holders or junior creditors. We'll give you, junior note holder, a security that is subordinate in right and only ends up having value if and when the company's valuation becomes higher because extraneous circumstances change. And I agree, you have to have some time limit. It can't be a warrant that goes on for 100 years. But if you give those folks some sort of upside, I think you end up getting to a lot greater and faster peace in cases and getting to a result that frankly seems more equitable. So I think that's a sensible solution. In the cases I've been involved in, people have sort of sometimes accepted the premise, then the devil is in the detail. What's the strike price on the warrants? What's their expiration and the like?
So I have Marty, then Steve Levin, and then Dennis.
You know, in so many cases, I see management with terminal euphoria. And I'm thinking back to, I think, at one of these programs when Ed Altman talked about Chapter 22, Chapter 33. I was in a CLE program where the lawyer last week was in a Chapter 44, and it's fundamentally valuation problems. And even, you know, you think that 363 sales, there's a market test for value. Some years ago, I had a case, BHS&B. It was 4 or 5 months after Judge Gropper had Stephen Barry's, which was the earlier iteration of it. It was bought in a 363 sale, and within 5 months, it was in another Chapter 11. Fundamental valuation problems.
Actually, Marty, just would those cases have been different if instead of emerging from bankruptcy with bond debt, they'd emerged from bankruptcy with an equity structure or with options?
I don't, I suppose so.
Yeah,
because
no,
they'd be, you know, that all those people would have been out of the money, but.
Steve?
So Don, you glanced on this slightly, and Oscar and I think, are going to talk about this a little bit in the next panel, but at what point do you reach a tipping, though, where you layer on the various derivative securities because you want to avoid the valuation fight, but then it becomes unclear what the distributions are in the case, right? Because you've so made the capital structure so opaque that you don't know who's getting what, right? And so is there a clear tipping point, or?
I don't think there is anything clear about this. Look, most of these situations where we've used warrants and options have been negotiated against the backdrop of the absolute priority rule, because everyone's afraid to get a valuation. I mean, in a way, the Mirror case was a classic example. I mean, I don't remember the exact numbers, but it was sort of, you know, one constituency valued the company at $5 billion, another constituency valued, the debtor valued itself at $6 billion, and another constituency valued the company at $7 billion, and basically the judge split the difference and chose the 6. So it's very unpredictable where the hammer is going to come down and say who's in the money and who's out of the money, so people often will resolve that rather than litigate it by allocating options. That's actually what happened in Conseco. So I don't know what the clear cut. On the other hand, you know, then the equity holders have this overhang of options, and it's very hard for the equity holders to get value for their equity because of the overhang. So it's a real dilemma.
Dennis?
Yeah, I would like to pick up on what Don and someone on my right was saying moments ago. In the real world, on bankruptcy world, you're trying to do a transaction. You have a buyer and a seller, and both want to do a deal, but the valuation is at issue. Let's take a pharmaceutical company. Let's say we have a drug in its 3rd stage that's going to solve the Alzheimer problem or some other disease we're never going to be able to solve. And the management of the selling company is firmly of the view that they're going to successfully get FDA approval and market it successfully. And they say, gee, our company is worth $40 a share because of this asset, and
the buyer who loves the rest of the portfolio of assets says, well, you know, we love the company, we value it at 32, really don't see the $8 a share you want to take for this third phase drug. Why don't we have a contingent value note to bridge the gap that will even make it tradable? That, not that I understand much about bankruptcy, but that would seem to be something that would make a lot of sense in this impossible issue of valuing something in bankruptcy which doesn't have a real management or not a continuing management, and half the time it's execution as opposed to the package of assets you're selling. So if you went with some sort of contingent value note, that if you're looking for fairness, that really is a way to achieve it.
That's sort of the conceivable solution. That was what they were thinking.
Jay.
Henry, it's odd, but I haven't asked you this question in a while. So when you and I wrote the Columbia piece, we thought a lot about, well, at what point should a board of directors have some kind of duty to file in, especially given the availability of Chapter 11 in our legal culture. And we sort of left that as a very tough question that we didn't know how to answer. Much of what...
It's for a funding, research funding proposal that we've delivered.
There you go, absolutely. So I guess my question is, not having discussed this with you for a while, is have you thought some more about that? And given the fog of lack of information and not knowing what to disclose, I was struck by the fact that if you start going in the direction of the Sears thing, where now you've got to say, well, you know, we're basically broke, right? And the question of whether a legal proceeding will follow is, you know, is not clear. Isn't there a point in there, really even stimulated by the new rule, where you really have to say there's a duty to file for bankruptcy?
That's an interesting issue. Sick corporations can remain sick for a long time before dying. And you also have situations where you may have a really dynamic executive coming in with tremendous strategies. So I don't really have a good answer for that. T-Mobile was really having terrible problems until, you know, the current CEO came in. I don't know, but I was really quite intrigued in terms of Don's discussion of this kind of option value concept on the bankruptcy side in terms of, because, you know, as you all know, you know, one of the things I'm really interested in is financial innovation, and this is a form of financial innovation to resolve some of these kinds of concerns. But no, I haven't, I'm not comfortable. I don't know what the answer is in terms of when you actually have to pull the trigger. But of course, creditors could pull the trigger on you anyway, right? So.
Well, certainly secured creditors can.
Yeah.
So actually, Jay's question creates a really interesting point of connection between what Don is talking about and what Henry's talking about, which is if the worry in bankruptcy, and the question that we're asking, that Don is asking is, when does realization happen, right? Does realization, which is to say the fixing of the value, for these purposes, the value of the claim, happen on bankruptcy? And the corporate law assumption is that when we put something into bankruptcy, we're liquidating, and therefore that's a realization moment. Now, that's sort of the metaphor that the world outside of bankruptcy thinks of bankruptcy as being. But Chapter 11, at least as Don is describing it in cases like Conseco and with the option preservation, is actually blurring the distinction between being in bankruptcy and being out of bankruptcy, in the sense that what you're doing is you're imposing a court supervision and an organizational process, but you're continuing to run the firm, which is to say that you're delaying a realization on the value of the firm, at least in that first instance, across the outside of bankruptcy and inside of bankruptcy divide. Now, that then becomes a problem within bankruptcy, which is if you do a sale, then you're realizing at that moment. If you're doing a plan, you have all sorts of options about how to structure the realization or the valuation. You can do all the Conseco kinds of things against the backdrop of a forced realization and cram down. So the
So if you sort of think about it that way, as instead of being a hard moment in bankruptcy of filing, but you think of bankruptcy as a simply transition into administration, if you will, but not realization, does that change your view of Jay's question?
Well, the basic shtick of our Columbia piece was basically that there are two governance systems, and that the state law-oriented corporate governance system has no mechanism to make adjustments among different groups of different constituencies, and that the bankruptcy system really does. And so, given, I guess the more I think about it, the more I think maybe we should push for earlier, kind of obligation to go into bankruptcy so that these kinds of mechanisms can play out. You have the weird system under this. One of the reasons we just so hated Chancellor Allen's approach in Credit Lyonnais, and also the muted form in North American Catholic, is in terms of the notion that you have different constituencies. State corporate law isn't set up for that. You give votes to just shareholders. You don't give votes to other people. You have the weird dichotomy where you're voting for, actually, if you're a shareholder, you want to vote for somebody who basically would, if there is this kind of fiduciary, ignore the fiduciary duty, and that maybe, in terms of this, an earlier push to the bankruptcy approach does make sense, but I still haven't answered the question, like, what does that mean? What the heck does that mean if you're talking about a troubled company? Because there's so many, troubled companies out there, and they go in and out of in a sense, in and out of technical insolvency, right, along the way.
Well, I think, the way this tends to work when you're talking about a corporate board is the board is very much focused on what's going to protect the value of the enterprise. They don't know who the residual beneficiary class is going to be, but they are very focused on the delta between foreclosure value, where creditors are exercising remedies, and going concern value in the sense that they can keep the operations going. And very often, you can keep the operations going outside of bankruptcy until you run out of cash, and then get a dip financing and keep them going in bankruptcy. So you're not really having an adverse impact on the value of the enterprise by waiting. And of course, hope springs eternal, and you hope that you can do a restructuring out of court. And there are many, many reasons why a board might delay a bankruptcy filing. Bankruptcy is not a great thing. It's expensive. It actually can impact adversely the value of the business. So usually, boards will say, unless we're in extremis, we're not going to take the step of preserving the going concern value by going into reorganization. We will try to do everything we can to find a solution outside of bankruptcy. So, and I think every case is different. There are many cases where an early bankruptcy filing is great. For a car company, for example, I think it would be a bad thing, because people rely on warranties. And if you've got a 5-year warranty going into bankruptcy without a solution that's going to be implemented right away, the way GM and Chrysler turned out, you run a serious risk that the business will decline in value. People aren't going to buy a car and hope that the parts are going to be available 5 years from now if you're going out of business. Or at least that was the fear, and that was one of the reasons why I think directors of auto companies felt that they should try everything they could to resolve their problems outside of bankruptcy, and actually Ford was successful at doing that. So I think this is a very difficult question. I don't think there's any one answer.
Let me just say that I think that obviously there's much to what you say, Don. On the other hand, thinking back to our discussion last night, I mean, there are also a lot of people flying around in airplanes that have flown through Chapter 11, right? And that's kind of scary if you really want to think about that. But we've all done it. We all do it. So I think there are a lot of businesses in which that's not true. And I think
for most businesses, the harm from bankruptcy is exaggerated.
Yeah, I think that's clearly right, and that's been my feeling going back all those years to my experiences in the late 70s. Yeah. But, so the question I want to raise is, thinking back to last night, a possible rule, at least as a presumption or as a minimum rule or something like that, would be when the board of directors and the management actually feels that there isn't anything left for equity, right? And we're told that very often the filing is done at a time when they think there's nothing left for equity. Maybe that ought to be a trigger for a duty to invoke the public court process in order to have the benefit that Henry and I talked about in the Columbia piece of now we have a mechanism, a governance mechanism that makes sense for the circumstance of the company, and it's one that doesn't doom it to liquidation, as we know. At least it seems to me that's a possible, a rule that we maybe ought to think about, so that the board would at least be forced to focus on that question as early as possible in this situation.
I have a little bit of discomfort with that in the sense that it depends on the percentage of yes men and women you have working for you in terms of the board. They'll tell you whatever, number you want, give you whatever result you want, right, in terms of whether or not there's any value left.
As academics, we get to talk about what they should do.
So I'm Oscar, and then Bob, and then we'll move to coffee.
Okay, yes, I don't want to mess up things even more than this, but what strikes me is that when I'm looking at back in the, let's say the 90s, or when Oliver Hart was also publishing on these option theoretical solutions to these bankruptcy issues. What that struck me, and also today is, and partly also due to the discussion by Henry, is that if you look at the information problem in bankruptcy, and the fact that people inside or outside have information, it's obvious there is an information asymmetry here that's very wide. But even the bigger problem might be that the value of that information, and especially looking forward, because that's the thing that we're doing, obviously we're looking forward. That's very much out there in the mist. We do not know. So we can structure all kinds of option and warrant-like structures for the future in the bankruptcy case, but nobody ever will know at that moment in time what kind of value is going to be associated with that, and that makes the difference. Bankruptcy doesn't change that much, with respect to also solvent firms, and I think that's whatever way we want to solve this kind of issue, it will be coming back towards the fact that one way or the other you have to hammer it down, but that necessarily is the value of the company. So, and I think that's the real difficulty that's so hard to solve here.
One thing I didn't mention is that, securities law, technically, the obligations still continue, even though you file for bankruptcy. But, interestingly, right, under certain circumstances, relying either on no action letters or the general kind of SEC release that the SEC has adopted, you can go for modified reporting. So much lighter reporting. So you're thrown back to the disclosures that are available under the bankruptcy system, which I'm told is much less granular than what the SEC requires. And this information is just really critical to figuring out the option value and so forth.
Yeah, but the other, I think, the bigger issue is even that kind of information, the value of that information, you can doubt that very much, and it's not so much disclosure in itself that might be the problem, but what are you actually going to disclose, and who is telling you what? Yeah, so and there's no one who would be right. So, sorry.
You're disclosing we don't know what the value of the company.
No, we don't know. Yes, we don't know.
Okay, we've got a judge here.
I'd like to suggest
Stop, look, and listen before we ever enacted a requirement that there be a requirement to file even for Chapter 11.
contrast to
European jurisdictions might otherwise do. Don made a hugely important point about how destructive an 11 can be, and when I had
GM before Marty did.
I had it for 6 years, including the sale. I got evidence about the concerns
About
warranties, about the concerns for not assuming liabilities for people who might buy cars that were manufactured before the sale.
had bricks thereafter.
And one thing we haven't yet talked about, but which I think is helpful to keep in mind, is that history has taught us that free fall bankruptcies have additional risks and expense that rearranged bankruptcies with plan support agreements, restructuring support agreements, have, they're sometimes. I'm sorry? There's some, oh, much better, thank you. To call it a restructuring support agreement is sometimes deceptive if you don't have enough people who are parties to the agreement. But to allow the time to get restructuring agreements put in place and to stabilize the company in a pre-bankruptcy mode is something that is very often going to be extraordinarily valuable. And therefore, I would suggest that allowing for some play in the joints to optimize the time at which the filing takes place is helpful to the stakeholders and, of course, to the judge.
Okay, okay, do you want to jump on that? I think that's a perfect point to segue to coffee, and then we can pick up that question again later, because I think it's going to, I think the issue of, this issue is going to run straight through the day. Thank you. This is a great first panel, if I do say so myself.